Welcome to Learning Forever. I'm your narrator, James. Today you will hear the Common Law Handbook, a timeless guide to liberty, justice, and the responsibilities entrusted to free people. Sit back, relax, and reflect on the enduring truths that form the foundation of a just and righteous society. Before we get started, this video is sponsored by ELEVENLABS, the leading platform for realistic AI voice generation. Whether you're creating audiobooks, podcasts, or narrations like this one, ELEVENLABS gives your words a voice. Thanks again to ELEVENLABS for supporting this project, link down below. Common Law Handbook for Jurors, Sheriffs, Bailiffs, and Justices. It's the duty of jurors, sheriffs, bailiffs, and justices to resist all infringements upon the rights of the people without delay. Thomas Jefferson said, "Whenever people are well informed, they can be trusted with their own government." Clearly, the government cannot be in charge of deciding for themselves whether or not they should indict themselves on criminal charges or not. This is precisely why we have so much corruption in our government. It is the duty of the people to stand up as the faithful and wise stewards, Luke 12:42, and bring the servants who think themselves master back into subjection. Common law is common sense. The question each jurist must ask themselves is there an injured party? There is a common law principle which states that for there to be a crime, there must first be a victim. Corpus delicti. The state cannot be the injured party. In the absence of a victim, there can be no crime. This is what the grand jurist must discover. The constitutions of most of our states assert that all power is inherent in the people, that they may exercise it by themselves, in all cases to which they think themselves competent, as in electing their functionaries executive and legislative, and deciding by a jury of themselves, both fact and law, in all judiciary cases in which any fact is involved. Or they may ask by representatives, freely and equally chosen, that it is their right and duty to be at all times armed, to freedom of person, freedom of religion, freedom of property, and freedom of the press. Thomas Jefferson, Letter to John Cartwright, June 5, 1824. The Thomas Jefferson Papers, Library of Congress. Grand Jurors. 25. It is the duty of the common law grand jury to expose all fraud and corruption, whether it is in the political or judicial realm, and stop it. The authority of the grand jury is found only in the Bill of Rights. Therefore, it comes from God and not government. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. It is, in effect, a fourth branch of government, governed and administered to directly by and on behalf of the American people. Trial Jurors and 12. It is the duty of the jury to execute justice and sometimes mercy. Their decisions cannot be second-guessed. The jury shall have the right to determine the law and the fact. New York Constitution, Article 1. As understood at common law and as used in constitutional provision, jury imports body of 12 men. Jury nullification. The jury has an unalienable right to judge both the law as well as the fact in controversy. John Jay, 1st Chief Justice, United States Supreme Court, 1789. The jury has the right to determine both the law and the facts. Samuel Chase, U.S. Supreme Court Justice, 1796, signer of the Unanimous Declaration. The jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court Justice, 1902. Central to the history of trial by jury is the right of jurors to vote not guilty if the law is unjust or unjustly applied. When jurors acquit a factually guilty defendant, we say that the jury nullified the law. The Founding Fathers believed that juries in criminal trials had a role to play as the conscience of the community, and relied on juries nullifying to hold the government to the principles of the Constitution. Trust in the jury is, after all, one of the cornerstones of our entire criminal jurisprudence. And if that trust is without foundation, we must re-examine a great deal more than just the nullification doctrine. Judge David L. Bazelon. There may be no feature more distinctive of American legal culture than the criminal trial jury. Americans have a deep and stubborn devotion to the belief that the guilt or innocence of a person accused of crime can only be judged fairly by a jury of his peers. This notion is a particularly American one, although it was inherited from English common law during the colonial era. Kentucky Resolutions. A series of resolutions drawn up by Jefferson and adopted by the legislature of Kentucky in 1799, protesting against the alien and sedition laws, declaring their illegality, announcing the strict constructionist theory of the federal government, and declaring nullification to be the rightful justice. It is the duty of the justice to do justice. In common law, the title justice given in England to the judges of the King's Bench and the Common Pleas, and in America to the judges of the Supreme Court of the United States and of the appellate courts of many of the states. In the most extensive sense of the word justice differs little from virtue, for it includes within itself the whole circle of virtues. Yet the common distinction between them is that which, considered positively and in itself, is called virtue, when considered relatively and with respect to others, has the name of justice. But justice, being in itself a part of virtue, is confined to things simply good or evil, and consists in a man's taking such a proportion of them as he ought. Bouvier. The source of virtue is found in Luke 6:19. And the whole multitude sought to touch him, for there went virtue out of him and healed them all. Therefore, a justice is to reflect divine qualities, as we read in Philippians 4:8. Finally, brethren, whatsoever things are true, whatsoever things are honest, whatsoever things are just, whatsoever things are pure, whatsoever things are lovely, whatsoever things are of good report. If there be any virtue and if there be any praise, think on these things. Sheriff, America will never be destroyed from the outside. If we falter and lose our freedoms, it will be because we destroyed ourselves. Abraham Lincoln. The county sheriff is the last line of defense when it comes to upholding and defending the Constitution. The sheriff's duties and obligations go far beyond writing tickets, arresting criminals, and operating jails. The sheriff also has an obligation to protect the constitutional rights of the citizens in our counties. This includes the right to free speech, the right to assemble, and the right to bear arms. Remember the oath. Sheriffs took an oath to uphold and defend the Constitution from enemies foreign and domestic. In the history of our world, it is government tyranny that has violated the freedoms granted to us by our Creator more than any other. And it is the duty of the sheriff to protect their counties from those that would take away our freedoms, both foreign and domestic, whether it is a terrorist from Yemen or a bureaucrat from Washington, D.C. Bailiff. Officers who perform the duties of sheriffs within liberties or privileged jurisdictions, in which formerly the king's writ could not be executed by the sheriff. One to whom some authority, care, guardianship, or jurisdiction is delivered, committed, or entrusted. One who is deputed or appointed to take charge of another's affairs. An overseer or superintendent. A keeper, protector, or guardian. A steward. Spellman. A sheriff's officer or deputy. One blot comma, 344th. A court attendant. It is the duty of all above to correct injustice inasmuch as it is in their power to do so. If correction is not possible, it is the duty of the court officer to report the problem to the protectors of the people, the Grand Jury, in whose hand justice has been entrusted. United States Codes. Remedy of the people when rights violated. USC 18, Section 2382, Misprision of treason. Whoever having knowledge of treason conceals and does not make known the same to some judge is guilty of treason for contempt against the sovereign, and shall be fined under this title or imprisoned not more than 7 years or both. United States Code 18, Section 201, bribery. Of any public official directly or indirectly gives, offers, or promises anything of value to any person to influence any official act. USC 18, Section 2. 41. Conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state in the free exercise or enjoyment of any right, they shall be fined under this title or imprisoned not more than 10 years or both. USC 18, Section 2. 42. Deprivation of rights under color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, the deprivation of any rights shall be fined under this title, or imprisoned not more than 1 year, or both. United States Code 18, Section 2071. Whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, documents filed or deposited with any clerk or officer of any court shall be fined or imprisoned not more than 3 years or both. USC 18, Section 2076. Clerk is to file. Whoever, being a clerk, willfully refuses or neglects to make or forward any report, certificate, statement, or document as required by law, shall be fined under this title or imprisoned not more than 1 year or both. USC 42, Section 1983. Civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage, of any state subjects or causes to be subjected, any person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law. U.S.C. 42, Section 1985. Conspiracy to interfere with civil rights. If two or more persons in any state or territory conspire for the purpose of depriving, either directly or indirectly, any person's rights, the party so injured or deprived may have an action for the recovery of damages against any one or more of the conspirators. U.S.C. 42, Section 1986. Action for neglect to prevent. Every person who, having knowledge that any of the wrongs conspired to be done or are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured. Government by consent. Our founders purposely placed the power of the grand jury in the Bill of Rights to make it clear that it belongs to the people and the government is not to violate it. It is the ultimate power of the people which allows them to consent, or not to the actions of their servant government. It also prevents government from unrighteous prosecutions by forcing the government to seek permission from the people before criminal charges can be filed. If the people refuse, it cannot go forward. By understanding this principle, it becomes clear that the government has no authority to control your behavior, and therefore neither do legislators without your consent. The Declaration of Independence says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. All men decide for themselves whether they want to participate in the institutions of men or not." The United States Supreme Court confirmed this when they said, "Every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent." Cruden v. Neal, 2 North Carolina 338, May Term 1796. There are only 3 ways a court can hear a criminal complaint. 1. One or more of the people sign a sworn affidavit that they have been injured. 2. A prosecutor on behalf of the government brings an accusation before the grand jury, and the grand jury either indicts or does nothing. 3. The grand jury, by its own will, can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. And if it finds wrongdoing, it can present it to the court, and it must go to trial. No one can second-guess the grand jury unless the grand jury's actions violate another's unalienable rights. Principle of liberty. Consent and jurisdiction. It's all about consent and jurisdiction. In order to possess liberty, it is extremely important that you understand consent. Our servant government cannot do anything without your consent. Consent of authority. We read in the Declaration of Independence, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Any authority our servants have is by our consent. If they act outside their authority, they are subject to criminal charges under U.S. Codes 42 and 18, and liable for damages under U.S. Codes and common law. The Fifth Amendment states, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury." Therefore, our servant government requires the people to get an indictment. Grand jury. Judges, servant, have no authority to make a ruling or a judgment on people, master, without your consent. In legal terms, when the judge asks you, "Do you understand?" he means, "Do you stand under the authority of this court?" So when you say yes, you just gave him her jurisdiction over you. Only people can judge. Our U.S. Constitution only authorizes common law courts, aka courts of record. A court of record removes the power of the judge to make a ruling. His role is that of the administrator of the court. The final determinator is the tribunal, who is either the sovereign plaintiff or a jury. Remember, the servant cannot rule over the master. Can the clay rule over the potter? Every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Cruden v. Neal. Herein is liberty, If you do not give a court consent, they have no jurisdiction over you. Under U.S. Codes 42 and 18, when you are detained without your consent for violating a statute, you have just been kidnapped. And if the judge sets a bail, he just set a ransom. And when the prosecutor confirms the charges, they are all part of a conspiracy, and you can put them in jail and sue them for damages. It's all about consent and jurisdiction. The real law. The common law is the real law, the supreme law of the land. The code, rules, regulations, policy, and statutes are not the law. Self v. Ray, 61 2nd, 261. Legislated statutes enforced upon the people in the name of law is a fraud. It has no authority and is without mercy. Justice without mercy is godless and therefore repugnant to our United States Constitution. Lawmakers were given authority by the people to legislate codes, rules, regulations, and statutes, which are policies, procedures, and law to control the behavior of bureaucrats, elected and appointed officials, municipalities, and agencies. But were never given authority to control the behavior of the people, as we read in a U.S. Supreme Court decision. All codes, rules, and regulations are for government authorities only, not human creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. Rodriguez v. Ray Donovan. And again, all laws, rules, and practices which are repugnant to the Constitution are null and void. Marbury v. Madison, 5th U.S., 2 Cranch, 137, 174, 176, 1803. Legislators simply don't have the authority to rule-make. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda v. Arizona, 384 U.S. 436, 491. God breaks down the law as follows. And Jesus answered him, "The first of all the commandments is, Hear, O Israel, the Lord our God is one Lord. And thou shalt love the Lord thy God with all thy heart, and with all thy soul, and with all thy mind, and with all thy strength. This is the first commandment. And the second is like, namely this, thou shalt love thy neighbor as thyself. There is none other commandment greater than these." Mark 12:29-31. Although it is a sin, punishable only by the judge of the universe, to break the commandment to love in your mind, words, and deeds. It does not become a crime, punishable by man, until your words and deeds are expressed in actions that injure another. Thomas Jefferson said, "I would rather be exposed to the inconveniences attending too much liberty than those attending too small a degree of it." If one of the people exercises his free will to carry a weapon, travel, practice law, park without depositing money in a meter, use hemp, pharmaceuticals, alcohol, vitamins, minerals, or any other substance for medicinal or recreational purposes, the legislators do not have the authority to impose a fine, license, or make a right a crime. Rights and sovereignty. Only people are sovereign and have rights. Bureaucrats in their capacity are not sovereign and have no rights. They have authority given by the people and are subject to the statutes. The state cannot diminish rights of the people. Hurtado v. People of the State of California, 110 U.S. 516. The assertion of federal rights, Bill of Rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis v. Wexler, 263 U.S. 22, 24. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda v. Arizona, 384 U.S. 436, 491. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Scherer v. Cullen, 481 F. 946. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. Yick Wo v. Hopkins, 118 U.S. 356, 370. Undersigned is sovereign, and no court has challenged that status or standing. To deprive the people of their sovereignty, it is first necessary to get the people to agree to submit to the authority of the entity they have created. That is done by getting them to claim they are citizens of that entity. See Constitution for the USA, 14th Amendment, for the definition of a citizen of the United States. Licensing liberty. No state shall convert a liberty into a license and charge a fee therefor. Murdoch v. Pennsylvania, 319 U.S. 105. If the state converts a right liberty into a privilege, the citizen can ignore the license and fee and engage in the right liberty with impunity. Shuttlesworth v. City of Birmingham, Alabama, 373 U.S. 262. Remedy for every injury, William Blackstone. A legal maxim. Every right when withheld must have a remedy, and every injury its proper redress. In the third volume of his commentaries, page 23, Blackstone states 2 cases in which a remedy is afforded by mere operation of law. In all other cases, he says, it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever that right is invaded. And afterwards, page 109 of the same volume, he says, I am next to consider such injuries as are cognizable by the courts of common law. And herein I shall, for the present, only remark that all possible injuries whatsoever that did not fall within the exclusive cognizance of either the ecclesiastical, military, or maritime tribunals are, for that very reason, within the cognizance of the common law courts of justice. For it is a settled and invariable principle in the laws of England that every right, when withheld, must have a remedy, and every injury its proper redress. 5 U.S. 137, Marbury v. Madison. The government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Marbury v. Madison, 5 U.S. 137, 1803, that statutes which would deprive a citizen of the rights of person or property without a regular trial, according to the course and usage of common law, would not be the law of the land. Hoke v. Henderson, 15, N.C. 1525 A.M., December 6-7-7. The right to be let alone the most comprehensive of rights and the right most valued by civil. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Olmstead v. U.S. 277, U.S. 438, 478, 1928. Section Court. The court belongs to the sovereign, plaintiff, people. Black's Law Dictionary, 5th edition, page 318, defines the court as the person and suit of the sovereign, the place where the sovereign sojourns with his regal retinue, wherever that may be. In the U.S. Supreme Court case, Isbell v. Stovall, the court was defined as an agency of the sovereign created by it directly or indirectly under its authority, consisting of one or more officers, established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law, authorized to exercise its powers in the course of law at times and places previously determined by lawful authority. Section Judicial Notice. Judicial Notice. Judicial notice or knowledge upon which a judge is bound to act without having it proved in evidence. Black's Law 4th edition. Take judicial notice of American Jurisprudence Book. 16. Constitution. Law section which a judge is bound by oath to obey. Section Judges sworn to obey. Constitution. Judges sworn to obey. Constitution. Irrespective of opinion and consequences, Constitution rules over statutes. Since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions and irrespective of the consequences. Thus it is said that the courts should be in our alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise in accordance with these basic principles. The rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment it is directly drawn into question. If the Constitution prescribes one rule and the statute the another in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. 16. American Jurisprudence. Second, Section 155. Supremacy Clause. This Constitution and the laws of the United States, which shall be made in pursuance thereof, And all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. U.S. Constitution. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. After more than 200 years, this decision still stands. Marbury v. Madison, 5 U.S. 137, 1803. Common law is still law of the land. All cases which have cited Marbury v. Madison case to the Supreme Court have not ever been overturned. See Shepard's citation of Marbury v. Madison. The Constitution was ordained and established by the people for the United States of America, aka government. Therefore, government was created by an act of the people. Therefore, the creation cannot trump the creator. If any statement within any law which is passed, section unconstitutional, the whole law is unconstitutional. Marbury v. Madison, 5 U.S. 137, 1803. Therefore, no legislation, that statutes which would deprive a citizen of the rights of person or property without a regular trial according to the course and usage of common law would not be the law of the land. Hoke v. Henderson, 15 N.C. 15:25 A.M., December 677. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda v. Arizona, 384, U.S. 436, 491. Interpretation in favor of the people. Any constitutional provision intended to confer a benefit should be liberally construed in favor in the clearly intended and expressly designated beneficiary. 16 American Jurisprudence. Second Section 98. Constitutions must be construed to reference the common law. Summary proceedings are null and void. As to the construction, with reference to common law, an important canon of construction is that constitutions must be construed to reference to the common law. 16 American Jurisprudence. Second Section 114. Shall not infringe. Various facts of circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. 16 American Jurisprudence. Second Section 117. Irreconcilable conflict between statute and constitution is to be resolved in favor of the constitutionality and the beneficiary. In all instances where the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. 16 American Jurisprudence. Second Section 255. Supreme law is the basis of all law. All fiction of law is null. No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Rodriguez v. Ray Donovan. The common law is the real law, the supreme law of the land. The code, rules, regulations, policy, and statutes are not the law. Self v. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law as in reality, no law. 16 American Jurisprudence. Second Section 256. Congress cannot alter rights. On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. 16 American Jurisprudence. Second, Section 258 rights do not come in degrees. Although it is manifested that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there is no degree of constitutionality. 16 American Jurisprudence. Second, Section 260. States cannot license rights. No state shall convert a liberty into a license and charge a fee therefor. States cannot license rights. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involves restraints and advance the constitutional liberties of press and religion, and inevitably tends to suppress their existence. That the ordinance is non-discriminatory, and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position. Since the privilege in question is guaranteed by the federal Constitution and exists independently of the state's authority, the inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert any secured liberty into a privilege and issue a license and a fee for it. Mouduk v. Pennsylvania, 319, U.S. 105:1943. If the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and a fee and engage the right with impunity. Shuttlesworth v. Birmingham, I-373, U.S. 262:1962. Officers of the court have no immunity when violating constitutional right from liability. The right of action created by statute relating to deprivation under color of law of a right secured by the Constitution and the laws of the United States, and comes claims which are 19 based solely on statutory violations of federal law, and apply to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Owen Volume 100 Supreme Court Reports, 1398, 1982, Maine Visur Tibuto 100 Volume. Supreme Court Reports, 2502:1982, Title 18 U.S. Code Section 241 and Section 242. If upon conviction, you are subject to a $10,000 fine, 10 years in jail, or both, and if theft results, life in prison. Title 42, U.S. Code Section 1983, Section 1985, and Section 1986 clearly establish the right to sue anyone who violates your constitutional rights. The Constitution guarantees he who would unlawfully jeopardize your property loses property to you, and that's what justice is all about. Judges are deemed to know the law and are sworn to uphold it, and can hardly claim that they acted in good faith for willful deformation of a law, and certainly cannot plead ignorance of the law. For that would make the law look unintelligent for a knowledgeable judge to claim ignorance of a law when a citizen on the street cannot claim ignorance of the law. Therefore, there is no judicial immunity. Constitutional preambles. Both constitutions, U.S. and New York, and the Constitution of any real republic, the operative word is establish and ordain. The people existed in their own individual sovereignty before the Constitution was enabled. When the people establish a constitution, there is nothing in the word establish that signifies that they have yielded any of their sovereignty to the agency they have created. To interpret otherwise would convert the republic into a democracy. Republic versus democracy. Government. We the people are a republic, not a democracy, which is just the first step to an oligarchy. Republican government. One in which the powers of sovereignty are vested in the people and are exercised by the people, either directly or through representatives chosen by the people, to whom those powers are specially delegated. Inra Duncan, 13920 U.S., 449, 11 S. Secchi, 573-35, Eled 219, Minor Verst Happerset, 88 U.S., 21 Wall, 162, 22 Eled 627. Black's Law Dictionary, 5th edition, page 626. Democracy government. That form of government in which the sovereign power resides in and is exercised by the whole body of free citizens directly or indirectly through a system of representation, as distinguished from a monarchy, aristocracy, or oligarchy. Black's Law Dictionary, 5th edition, page 388, Bond ver U.S., SCOTUS, recognizes personal sovereignty, June 16, 2011. Duty of courts. It is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Boyd v. United States, 116 U.S. 616, 635. It will be an evil day for American liberty if the theory of a government outside supreme law finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violations of the principles of the Constitution. Downs v. Bidwell, 182 U.S. 244, 1901. We, judges, have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. It may be that it is the obnoxious thing in its mildest form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. This can only be obviated by adhering to the rule that constitutional provisions for the security of persons and property should be liberally construed. A close and literal construction deprives them of half their efficacy and leads to gradual depreciation of the right, as if it consisted more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizens and against any stealthy encroachments thereon. Their motto should be obsta principiis. Boyd v. United, 116 U.S., 616 at 635, 1885. Courts of record are common law courts, and therefore courts of justice. Bouvier's Law, 1856 edition. This phrase is used to point out that a thing is to be done according to the course of the common law. It is distinguished from a proceeding in equity. Any court that ignores due process, all statutory courts ignore due process, is not a common law court. Common law courts are courts of record. In all courts of record, the tribunal is the sovereign plaintiff of the court or the jury. The justice is the administrator and reflects the wish of the sovereign or jury, because the people rule not government servants. The following law of the land proves this point. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. A consequence of this prerogative is the legal ubiquity of the king. His Majesty in the eye of the law is always present in all his courts, though he cannot personally distribute justice. His judges are the mirror by which the king's image is reflected. Blackstone's Commentaries, 270. Judicial immunity. Judges are under the illusion that they have absolute immunity, but all the cases that are cited making such a claim are without authority. People and will fail in the federal and state courts in a court of record. Only the people are sovereign, all servants are under statutes, and therefore liable to USC 18 and 42. Where there is no jurisdiction, there can be no discretion. They are not above the law. When they commit a crime, they will go to jail, and 23 are subject to civil suits. No man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who, by accepting office, participates in its functions, is only the more strongly bound to submit to that supremacy and to observe the limitations which it imposes on the exercise of the authority which it gives. There is a general rule that a ministerial officer who acts wrongfully, although in good faith, is nevertheless liable in a civil action and cannot claim the immunity of the sovereign. Cooper v. O'Connor, 99, F.2, D133. Any judge who does not comply with his oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. Cooper v. Aaron, 358 U.S. 1, 78 SSA, 1401, 1958. A judge must be acting within his jurisdiction as to subject matter and person to be entitled to immunity from civil action for his acts. The courts are not bound by an officer's interpretation of the law under which he presumes to act. Where there is no jurisdiction, there can be no discretion, for discretion is incident to jurisdiction. Right to practice law. The term liberty denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, to establish a home and bring up children, to worship God according to the dictates of this own conscience. The established doctrine is that this liberty may not be interfered with under the guise of protecting public interest by legislative action. Meyer v. Nebraska, 262 U.S., 390, 399, 400. A state cannot exclude a person from the practice of law or from any other occupation in a manner or for reasons that contravene the Due Process Clause of the 14th Amendment. Schwer v. Board of Bar Examiners, 353 U.S. 232, 1957. There can be no sanction or penalty imposed upon one because of his exercise of constitutional rights. Scherer v. Cullen, 481, F. 2nd 946, 1973. The practice of law cannot be licensed by any state. Schwer v. Board of Examiners, United States Reports, 353 U.S. pages, 238, 239. The practice of law is an occupation of common right. Sims v. Ahearns, 271 SW 720, 1925. The assertion of federal rights, when plainly and reasonably made, are not to be defeated under the name of local practice. Davis v. Weckler, 263, U.S. 22, 24. Stromberg v. California, 283, U.S. 359. NNACP v. Alabama, 375 U.S. 449. The right to file a lawsuit pro se is one of the most important rights under the Constitution and laws. Elmore v. McCammon, 1986. 640 F. Suppiador 905. The right to assist. Litigants can be assisted by unlicensed laymen during judicial proceedings. A next friend is a person who represents someone who is unable to tend to his or her own interest. Federal Rules of Civil Procedures, Rule 17, 28. USCA. Next friend. Members of groups who are competent non-lawyers can assist other members of the group achieve the goals of the group in court without being charged with unauthorized practice of law. NAA. CPV button 371 U.S. 415. United Mine Workers of America v. Gibbs, 383 U.S. 715, and Johnson v. Avery, 89 South Court, 747, 1969. There, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellowmen without his consent. Cruden v. Neal, 2 North Carolina, 338, 1796. 2 Southeast, under our system of government upon the individuality and intelligence of the citizen, the state does not claim to control him/her, except as his/her conduct to others, leaving him/her the sole judge as to all that affects himself/herself. Mugler v. Kansas, 123 U.S., 623-659-60. The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis v. Wexler, 263 U.S. 22 at 24. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution. Murdoch v. Pennsylvania, 319 U.S. 105 at 113. The state cannot diminish rights of the people. Hurtado v. California, 110 U.S. 516. The claim and exercise of a constitutional right cannot be converted into a crime. Miller v. U.S. 230 F. 2nd 488. If the state converts a liberty into a privilege, the citizen can engage in the right with impunity. Shuttlesworth v. Birmingham, 373 USS 266. First principle. Liberty is mastered in 3 powers. 1. Light, God. 2. Justice, synonymous with virtue, judicial process. 3. Rule of destiny, political process. Remove anyone and you lose liberty. America has lost its way and only a virtuous people can guide her back. And so to that end, the people by the mercy of God have rediscovered the common, natural law, Grand Jury, and with his blessings shall return America to her roots again. Virtue maxims of law avow that justice and virtue are synonymous. Before a man can implement justice, he must first possess virtue, which the Bible declares flows from the Lord alone, Luke 6:19, and defines virtue as whatsoever things are true, honest, just, pure, lovely, and of good report, Philippians 4:8. The Lord further expounds, saying, the wisdom that is from above is first pure, then peaceable, gentle and easy to be entreated, full of mercy and good fruits, without partiality and without hypocrisy, James 3:17, and that he that follows after it establishes righteousness and honor, Proverbs 21:21. Thomas Jefferson understood this when he said, "God who gave us life gave us liberty. And can the liberties of a nation be thought secure when we have removed their only firm basis, a conviction in the minds of the people that these liberties are of the gift of God, that they are not to be violated but with his wrath? Indeed, I tremble for my country when I reflect that God is just, that his justice cannot sleep forever." George Washington understood this when he said, "The favorable smiles of heaven can never be expected on a nation that disregards the eternal rules of order and right which heaven itself has ordained." Benjamin Franklin understood this when he said, "Only a virtuous people are capable of freedom. As nations become corrupt and vicious, they have more need of masters." John Adams understood this when he said, "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other." Patrick Henry understood this when he said, "It cannot be emphasized too strongly or too often that this great nation was founded, not by religionists but by Christians, not on religions but on the gospel of Jesus Christ. For this very reason, peoples of other faiths have been afforded asylum, prosperity, and freedom of worship here." James Madison understood this when he said, "We have staked the whole future of American civilization, not upon the power of government, far from it. We have staked the future of all of our political institutions upon the capacity of mankind for self-government, upon the capacity of each and all of us to govern ourselves, to control ourselves, to sustain ourselves according to the 10 Commandments of God." Noah Webster understood this when he said, "No truth is more evident to my mind than that the Christian religion must be the basis of any government intended to secure the rights and privileges of a free people." Father of American scholarship and education. The name game people or citizen. 14th Amendment, Article 1, Section 1. All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Nation. In American constitutional law, the word state is applied to the several members of the American Union, while the word nation is applied to the whole body of the people embraced within the jurisdiction of the federal government. Cooley, Constable Lim. 1. Texas versus White, 7 Wall, 720, 19L. Ed. 227. Privilege. Black's Law 4th edition, 1891, is merely an accessory of the debt which it secures and falls with the extinguishment of the debt. Persons. Black's Law 4th edition, 1891, are divided by Iow into natural and artificial. Corporations or bodies politic. Quasi-municipal corporations, bodies politic and corporate, created for the sole purpose of performing one or more municipal functions. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. People are supreme, not the state. Waring versus the Mayor of Savannah. The state cannot diminish rights of the people. Hurtado versus California. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, with none to govern but themselves. Chisholm versus Georgia. The people of this state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Lansing versus Smith ordained to enact a constitution or law. State versus Dallas City. King is the sovereign ruler, holds the highest executive power, aka the people. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. And the law is the definition and limitation of power. Yick Wo v. Hopkins. History of the Sheriff. While most people in America recognize the sheriff as the chief law enforcement officer, CLEO, for the county, they would be surprised to know that the office of sheriff has a proud history that spans well over 1,000 years, from the early Middle Ages to our own high-tech era. The beginning. The Middle Ages. More than 1,300 years ago in England, small groups of Anglo-Saxons lived in rural communities similar to modern-day towns. Often at war, they decided to better organize themselves for defense. Sometime before the year 700, they formed a system of local self-government based on groups of 10. Each of the towns divided into groups of 10 families, called tithings. Each tithing elected a leader called a tithing man. The next level of government was a group of 10 tithings, or 100 families, and this group elected its own chief. The Anglo-Saxon word for chief was gerefa, later shortened to reeve. During the next 2 centuries, groups of hundreds banded together to form a new, higher unit of government called the shire. The shire was the forerunner of the modern county. Each shire had a chief, reeve as well, and the more powerful official became known as a shire reeve. The word shire reeve became the modern English word sheriff, the chief of the county. The sheriff maintained law and order within his own county with the assistance of the citizens. When the sheriff sounded the hue and cry that a criminal was at large, anyone who heard the alarm was responsible for bringing the criminal to justice. This principle of citizen participation survives today in the procedure known as posse comitatus. The office grows. English government eventually became more centralized under the power of a single ruler, the king. The king distributed huge tracts of land to noblemen, who governed the land under the king's authority. The office of sheriff was no longer elected but appointed by the noblemen for the counties they controlled. In those areas not consigned to noblemen, the king appointed his own sheriffs. After the Battle of Hastings in 1066, England's rule fell to the Normans, France, who seized and centralized all power under the Norman king and his appointees. The sheriff became the agent of the king, and among his new duties was tax collection. This dictatorial rule by a series of powerful kings became intolerable, and in 1215 an army of rebellious noblemen forced the despotic King John to sign the Magna Carta. This important document restored a number of rights to the noblemen and guaranteed certain basic freedoms. The text of the Magna Carta mentioned the important role of the sheriff 9 times. 29. Over the next few centuries, the sheriff remained the leading law enforcement officer of the county. It was an honor to be appointed sheriff, but it was costly. If the people of the county did not pay the full amount of their taxes and fines, the sheriff was required to make up the difference out of his own pocket. He also had to provide lavish entertainment for judges and visiting dignitaries at his own expense. The sheriff crosses the Atlantic. The first American counties were established in Virginia in 1634, and records show that one of these counties elected a sheriff in 1651. Most other colonial sheriffs were appointed. Just as the noblemen in medieval England, large American landowners appointed sheriffs to enforce the law in the areas they controlled and to protect their lands. American sheriffs were not expected to pay extraordinary expenses, however, and some actually made money from the job. Throughout the 18th and 19th centuries, colonial and state legislatures assigned a broad range of responsibilities to the sheriff, which included the familiar role of law enforcement and tax collection. Other duties were new, such as overseeing jails, houses of corrections, and workhouses. As Americans moved westward, so did the office of sheriff and the use of jails. Settlers desperately needed the sheriff to establish order in the lawless territories where power belonged to those with the fastest draw and the most accurate shot. Most Western sheriffs, however, kept the peace by virtue of their authority. With a few exceptions, sheriffs resorted to firepower much less often than we have seen depicted in movies and on TV. The sheriff today. There are over 3,000 counties in the United States, and almost every one of them has a sheriff except for Alaska. Some cities, such as Denver, St. Louis, Richmond, and Baltimore, have sheriffs as well. The office of sheriff is established either by the state constitution or by an act of state legislature. There are only 2 states in which the sheriff is not elected by the voters. In Rhode Island, sheriffs are appointed by the governor. In Hawaii, deputy sheriffs serve in the Department of Public Safety's Sheriff's Division. There is really no such thing as a typical sheriff. Some sheriffs still have time to drop by the town coffee shop to chat with the citizens each day. while others report to an office in a skyscraper and manage a department whose budget exceeds that of many corporations. However, most sheriffs have certain roles and responsibilities in common. Law enforcement. A sheriff always has the power to make arrests within his or her own county. Some states extend this authority to adjacent counties or to the entire state. Many sheriff's offices also perform routine patrol functions, such as traffic control, accident investigations, and transportation of prisoners. Larger departments may perform criminal investigations, and some unusually large sheriff's offices command an air patrol, a mounted patrol, or a marine patrol. Sheriffs still enlist the aid of the citizens. The National Neighborhood Watch Program, sponsored by the National Sheriff's Association, allows citizens and law enforcement officials to cooperate in keeping communities safe. This is why the new mission of the Indiana Sheriff's Association and slogan is, "Building communities of trust is all 92 Indiana counties." As the sheriff's law enforcement duties become more extensive and complex, new career opportunities exist for people with specialized skills: underwater diving, piloting, boating, skiing, radar technology, communications, computer technology, accounting, emergency medicine, and foreign languages, especially Spanish, French, and Vietnamese. Court duties. Sheriffs are responsible for maintaining the safety and security of the court. A sheriff or deputy may be required to attend all court sessions, to act as bailiff, to take charge of juries whenever they are outside the courtroom, to serve court papers, to extradite prisoners, to collect taxes, or to perform other court-related functions. Jail administration. Most sheriff's offices maintain and operate county jails or other detention centers, community corrections facilities such as work release and halfway houses. Sheriffs are responsible for supervising inmates, protecting their rights, and providing food, clothing, exercise, recreation, and medical services. As jail conditions continue to improve, sheriffs and their departments are earning increased respect and recognition as professionals. Law enforcement is becoming increasingly complex. For the progressive, forward-looking sheriff's offices of today, education and training are the keys to effective job performance. Today's sheriff is likely to have a college degree, a graduate degree in criminal justice, law or public administration, and several years' experience in the criminal justice system. Your Indiana Sheriff's Association, ISA, under the leadership of Executive Director Stephen P. Luce, is dedicated to working with ISA membership to ensure that the men and women who protect and serve the citizens of Indiana are the best trained and most qualified. President Ronald Reagan stressed the importance of the modern sheriff in his address to the National Sheriff's Association on June 21, 1984. He said, "Thank you for standing up for this nation's dream of personal freedom under the rule of law. Thank you for standing against those who would transform that dream into a nightmare of wrongdoing and lawlessness. And thank you for your service to your communities, to your country, and to the cause of law and justice." Justice Scalia, writing for the majority in a 1997 decision, said that the states are not subject to federal direction, and that the U.S. Congress only had discrete and enumerated powers, and that federal impotency was rendered express by the 10th Amendment. He confirmed that the sheriff is the chief law enforcement officer, CLEO, of the county, and also proclaimed that the states retained an inviolable sovereignty. Scalia went even further in this landmark decision, one in which two small-town sheriffs headed the feds off at the pass and sent them on their way. Scalia, in his infinite obligation to the Constitution, took this entire ruling to the 10th power when he said, "The Constitution protects us from our own best intentions, so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day." Obviously, the sheriff is the people's last line of defense against a government gone rouge. Only the people can save America, will you? I know no safe depositary of the ultimate powers of the society, but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true corrective of abuses of constitutional power. Thomas Jefferson. In a stunning 6-3 decision, Justice Antonin Scalia, writing for the majority, confirmed that the American Grand Jury is neither part of the judicial, executive, nor legislative branches of government, but instead belongs to the people. It is in effect a fourth branch of government governed and administered directly by and on behalf of the American people, and its authority emanates from the Bill of Rights. See United States v. Williams. In reality, there is only one grand jury within a state with locations in each county. We can draw off the jury pool from any county if necessary. When the administrators of each county come together on an issue, they can use the seal of each county on an arbitration or presentment document, which can produce extraordinary results. But in order to be successful, we must first seek the blessings from the Governor of the universe and build our endeavor upon him and his principles. 1. Honor, 2. Justice, and 3. Mercy. This is the only sure foundation. Any other will succumb to tyrants. Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. John Adams, man will ultimately be governed by God or by tyrants. Benjamin Franklin, Constitution of a Common Law Grand Jury. We the people, by the mercy and grace of God, having blessed us with the unalienable right of the people as grand jurors, secured by the Fifth Amendment of the Bill of Rights for the United States of America, in order to establish justice, ensure domestic tranquility, secure the blessings of liberty to ourselves and our posterity by the securing of natural law, do ordain and establish this grand jury principled upon justice, honor, and grace for a perpetual administration of trust on behalf of the people. Duty of the common law. Grand jury. If anyone's unalienable rights have been violated or removed without a legal sentence of their peers from their lands, home, liberties, or lawful right, we, the 25, shall straightway restore them. And if a dispute shall arise concerning this matter, it shall be settled according to the judgment of the 25 grand jurors, the sureties of the peace. Magna Carta, June 15, 1215, 52. Jurist Oaths. I vow to the Governor of the universe, in my capacity as jurist, to ensure that all public servants uphold the U.S. Constitution and Bill of Prohibitions, rights, and to carry out all of my deliberating under natural law, principled under justice, honor, and mercy, and to strictly adhere to the following 2 legal maxims. 1. Every right when withheld must have a remedy, and every injury its proper redress, and 2. In the absence of a victim, there can be no crime, corpus delicti. The state cannot be the victim. It is the duty of all the people to share in the governing of themselves and to secure their government by participating as a jurist. Think about this. If we the people can reinstate justice and demand that elected officials and bureaucrats obey the law or be indicted, we would have then succeeded in reinstating the Constitution. Only the people can stand up and defend the Constitution because the Constitution cannot defend itself, and bureaucrats will never do it. We need to pray and stand up for justice, for man will either serve God or tyrants. Hold on, my friends, to the Constitution and the Republic for which it stands. Miracles do not cluster, and what has happened once in 6,000 years may not happen again. Hold on to the Constitution, for if the American Constitution should fail, there will be anarchy throughout the world. Daniel Webster. Necessity is the plea for every infringement of human freedom. It is the argument of tyrants. It is the creed of slaves. William Pitt, November 18, 1783. I would rather be exposed to the inconvenience attending too much liberty than those attending too small degree of it. Thomas Jefferson. Unified Common Law. Grand Jury Mission Statement. Our mission is to restore the people to sovereignty through knowledge, and only then will they be armed with the virtue to take political and judicial power. The people have it in their power to disarm and defeat the enemy of liberty, both foreign and domestic, if they only understood the principles of freedom and stand upon them. To take political power is to control our elected representatives by bringing them into obedience through fear of the people. This is accomplished by understanding the office of becoming an elected committeeman, and then execute the powers. It's that simple. To take judicial power is to control our courts by understanding jurisdiction and bringing into subjection all government officers and officials using common law courts by opening courts of record and executing people authority. It's that simple. But to successfully apply political and judicial power, you must have a sense of justice and mercy, which is synonymous with virtue. And to get virtue, you need to have a relationship with your Creator. If everyone exercised these principles, America could shake off the chains of tyranny, reinstate our republic, and bring down the NWO literally overnight. This is the only way to save the nation. Without power, you are powerless. Join our endeavor and save our republic, one people at a time. We are nonpartisan. A partisan person is one who is blindly or unreasonably devoted to party positions. Therefore, a partisan cannot possibly serve the Constitution. George Washington warned us against political parties. He said, "They only succeed in pitting one group against another." The cause of the grassroots movement is the awakening to our constitutional crisis. For it to be engaged in partisan politics would further serve the demise of our constitutional republic. The genius of the progressive movement is their exploitation of partisan politics, which they created to subvert our Constitution. Grassroots groups are natural and spontaneous, whose primary objective is to reinstate the Constitution. To be partisan would be counterproductive. Traditional power structures are orchestrated and designed to harness grassroots movements. They must always be suspect and will be proven corrupt if they are partisan, divisive, take control of choosing candidates. Grassroots are founded local, control is local, and most events are local. To collaborate with distant groups are necessary for unity, but if events become dictated by them, you are no longer grassroots. All that is necessary for the triumph of evil is that good men do nothing. Edmund Burke. No God, no liberty, no God, no liberty. If the Son therefore shall make you free, ye shall be free indeed. John 8:36. If a nation expects to be ignorant and free, it expects what never was and never will be. Thomas Jefferson. The favorable smiles of heaven can never be expected on a nation that disregards the eternal rules of order and right, which heaven itself has ordained. George Washington. God who gave us life gave us liberty. And can the liberties of a nation be thought secure when we have removed their only firm basis, a conviction in the minds of the people that these liberties are of the gift of God, that they are not to be violated but with His wrath? Indeed, I tremble for my country when I reflect that God is just, that His justice cannot sleep forever. Thomas Jefferson. The worship of God is a duty. Benjamin Franklin. The fate of unborn millions will now depend, under God, on the courage of this army. Our cruel and unrelenting enemy leaves us only the choice of brave resistance or the most abject submission. We have therefore to resolve to conquer or die. George Washington. I am sure that never was a people who had more reason to acknowledge a divine interposition in their affairs than those of the United States. And I should be pained to believe that they have forgotten that agency, which was so often manifested during our Revolution, or that they failed to consider the omnipotence of that God who is alone able to protect them. George Washington. Only a virtuous people are capable of freedom. As nations become corrupt and vicious, they have more need of masters. Benjamin Franklin. Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. John Adams. Statesmen, my dear sir, may plan and speculate for liberty, but it is religion and morality alone which can establish the principles upon which freedom can securely stand. The only foundation of a free constitution is pure virtue, and if this cannot be inspired into our people in a greater measure than they have it now, they may change their rulers and the forms of government, but they will not obtain a lasting liberty. They will only exchange tyrants and tyrannies. John Adams. The safety and prosperity of nations ultimately and essentially depend on the protection and blessing of Almighty God. And the national acknowledgement of this truth is not only an indispensable duty, which the people owe to Him, but a duty whose natural influence is favorable to the promotion of that morality and piety without which social happiness cannot exist, nor the blessings of a free government be enjoyed. John Adams. Observe good faith and justice towards all nations. Cultivate peace and harmony with all. Religion and morality enjoin this conduct. And can it be that good policy does not equally enjoin it? Can it be that Providence has not connected the permanent felicity of a nation with its virtue? George Washington. Nothing can contribute to true happiness that is inconsistent with duty, nor can a course of action conformable to it be finally without an ample reward. For God governs, and He is good. Benjamin Franklin. Happiness, whether in despotism or democracy, whether in slavery or liberty, can never be found without virtue. John Adams. It cannot be emphasized too strongly or too often that this great nation was founded, not by religionists, but by God's children, not on religions, but on the gospel of Jesus Christ. For this very reason, peoples of other faiths have been afforded asylum, prosperity, and freedom of worship here. Patrick Henry. It is the duty of every man to render to the Creator such homage. Before any man can be considered as a member of civil society, he must be considered as a subject of the governor of the universe. James Madison. We have staked the whole future of American civilization not upon the power of government, far from it. We have staked the future of all of our political institutions upon the capacity of mankind for self-government, upon the capacity of each and all of us to govern ourselves, to control ourselves, to sustain ourselves. According to the 10 Commandments of God, James Madison religion, or the duty we owe to our Creator and manner of discharging it, can be directed only by reason and conviction, not by force or violence. James Madison. Let it simply be asked, where is the security for prosperity, for reputation, for life, if the sense of religious obligation desert the oaths, which are the instruments of investigation in the courts of justice? George Washington. And let us with caution indulge the supposition that morality can be maintained without religion. George Washington. Whatever may be conceded to the influence of refined education on minds of peculiar structure, reason, and experience, both forbid us to expect that national morality can prevail in exclusion of religious principle. George Washington. 'Tis substantially true that virtue or morality is a necessary spring of popular government. George Washington. Though, in reviewing the incidents of my administration, I am unconscious of intentional error, I am nevertheless too sensible of my defects not to think it probable that I may have committed many errors. Whatever they may be, I fervently beseech the Almighty to avert or mitigate the evils to which they may tend. George Washington Congress and President George Washington in 1789 passed the United States Annotated Code, Article 3, which states, "Religion, morality, and knowledge, being necessary to good government and the happiness of mankind, schools and the means of education shall forever be encouraged." Religion in law and government. In my view, the Christian religion is the most important, and one of the first things in which all children, under a free government, ought to be instructed. No truth is more evident to my mind than that the Christian religion must be the basis of any government intended to secure the rights and privileges of a free people. The father of American scholarship and education. Noah Webster. The brief exposition of the Constitution of the United States will unfold to young persons the principles of Republican government. And it is the sincere desire of the writer that our citizens should early understand that the genuine source of correct Republican principles is the Bible, particularly the New Testament, or the Christian religion. Noah Webster. The religion which has introduced civil liberty is the religion of Christ and his apostles, which enjoins humility, piety, and benevolence, which acknowledges in every person a brother or a sister and a citizen with equal rights. This is genuine Christianity, and to this we owe our free constitutions of government. Noah Webster. The moral principles and precepts contained in the Scriptures ought to form the basis of all of our civil constitutions and laws. All the miseries and evils which men suffer from vice, crime, ambition, injustice, oppression, slavery, and war proceed from their despising or neglecting the precepts contained in the Bible. Noah Webster. When you become entitled to exercise the right of voting for public officers, let it be impressed on your mind that the preservation of a Republican God commands you to choose for rulers just men who will rule in the fear of God. Government depends on the faithful discharge of this duty. Noah Webster. If the citizens neglect their duty and place unprincipled men in office, the government will soon be corrupted. Laws will be made not for the public good so much as for the selfish or local purposes. Noah Webster. Every master of slaves is born a petty tyrant. They bring the judgment of heaven upon a country. As nations cannot be rewarded or punished in the next world, they must be in this. By an inevitable chain of causes and effects, providence punishes national sins by national calamities. George Mason, father of our Bill of Rights, 1787. Common law is our heritage. Liberty is our inheritance. We the people have been lulled asleep, we have been robbed and persuaded to sell our birthright. Whoso looketh into the perfect law of liberty, and continueth therein, he being not a forgetful hearer, but a doer of the work, this man shall be blessed in his deed. James 1:25. My people are destroyed for lack of knowledge. Hosea 4:6. Wisdom is the principal thing, therefore get wisdom, and with all thy getting get understanding. Prov 4:7-40. We the people by the mercy and grace of God ordained with certain unalienable rights, among them the right to form and exercise this 25 people. Grand Jury in the spirit of the Magna Carta and our founding fathers and in obedience to God for this county, on behalf of the people, having recorded our authority with the county clerk and the state Supreme Court chief clerk, by which we act in order to establish justice, ensure domestic tranquility, secure the blessings of liberty to ourselves and our posterity, by the securing of natural law and thereby returning justice, honor, and grace for a perpetual administration of trust on behalf of the people hereby defined in the handbook. So let the wicked perish at the presence of God. Psalm 68, verse 2. Natural law. Love the Lord thy God with all thy heart, and with all thy soul, and with all thy mind. This is the first and great commandment, and the second is like unto it, thou shalt love thy neighbor as thyself. On these two commandments hang all the law and the prophets. Matthew 22:37-40. Thank you for watching. Remember to subscribe and drop a comment down below for more audiobooks. This has been James with Learning Forever. Have a great day.